then okay. Uh, Dear ladies and gentlemen, it's my distinct honor to introduce Professor Muhammad Wasim Ali, a distinguished scholar and esteemed member of Aligarh Muslim University community. Professor Ali holds a PhD in law and serves as a professor in the Department of Law at AMU.
चलिए अभी
His
कन्वे
academic
कराते हैं.
journey is marked by a profound commitment to legal
ठीक है.
education and research. Beyond his contribution in academia, Professor Ali has been entrusted with
अच्छा.
significant administrative responsibilities. Since February 2020, he has held the pivotal role of proctor at AMU, a position he continues to serve with dedication. In this capacity, he oversees the maintenance of law and order within the university, ensuring a secure and conducive environment for learning and growth. Professor Ali's leadership and unwavering dedication to the university values have been have earned him immense respect among colleagues and students alike. His multifaceted role as an educator, administrator, and mentor underscores his exceptional commitment to the advancement of legal education and the holistic development of the university community. Please join me in welcoming Professor Muhammad Wasim Ali. Sir, thank you for sparing time from your busy schedule, and I will be very grateful to have you in the session, sir. Please.
Thank you very much, Dr. Jisan Sahab. And I welcome all the participants in this session that has been scheduled by the uh, HRD Center, AMU Aligarh, for the interaction with the teachers of the Integral University. As I have been told that all the participants are from university. This is from the Integral University. So it's a great privilege for me to have interaction with the teachers of the Integral University. In fact, it should not be called as a teaching because all of you are teachers, and therefore there is no question of taking the class or teaching. Only it will be a kind of interaction on the subject, whatever may be. In fact, as I have been introduced by learned coordinator of the program, Dr. Jishan Sahab, that right now I am a professor in the faculty of law, AMU Aligarh, and have been teaching law subjects for last about 25 years, more than 25 years. And my area of specialization and teaching, in fact, is family law. That is Muslim law and Hindu law I have been teaching. Sometime 10 or 15 years before, for a few years, I also taught this subject, that is Constitution. And therefore, director of HRD Center told that, rather requested that I should engage participants on a topic from the field of Constitution. And I agreed because so far as the Constitution is concerned, it is a subject of common interest for all the teachers, particularly faculty of law or department of law, because as I have been told that a good number of the participants are from faculty of law, department of law, Integral University, and some are from other departments, maybe engineering or some other faculties, but there are certain areas from the Constitution which, of course, are of the common interest, and the teachers or participants from other discipline may take more interest in the subject of law, because now the scope of law is increasing day by day, and therefore even uh, teachers and person belonging to the other discipline, they are also working on the basic rules of the law, that like environmental law, AI, artificial intelligence. Now these are the developing areas which are directly connected to the legal discipline. Therefore, even teachers from faculty of engineering, faculty of science, they want to know what are the basic or fundamental rules, particularly from the area of constitution. And therefore, I thought that, of course, it would be a good occasion to reflect upon some topic from the field of the constitution. But because of my busy schedule, because in the university today there was admission committee meeting, and it started from 10, and was over about 4:40, 4:30, and therefore I had to shift my schedule of lecture from 3 to 5:40 or 5:45. Anyhow, the topic which has been assigned for discussion with you by the center, Retd center, that is fundamental duties or constitutional duties. Ladies and gentlemen, as all of you are maybe well aware, because so far as the constitution is concerned, constitution is no need to repeat, but that this is called a document of national importance, uh, and it is the document basically which facilitate the good governance of the country. So the governance, the good governance of the country basically is the concept or idea of the good governance is enshrined in the various provisions of various provisions and articles of the constitution, and therefore this document or this constitution is held as one of the most important a document, a national document, because the entire uh, structure of the government basically is based on the uh, constitution or the various articles or provisions of the constitution. What are the various organs of the government? What will be the role or what will be the function and duties of the various organs of the government? Maybe the legislature, maybe executive, or maybe judiciary. What are their powers? What are their functions? What are their responsibilities? So all these things are outlines regarding all these institutions is provided in the scheme of the constitution under the different articles. Uh, all of you may be aware that what is the role of the parliament, how the parliament is constituted, who are entitled to be the members of the parliament, or uh, state legislature, as the case may be. At the same time, what is the uh, uh, roles and responsibilities of the executive under the scheme of the constitution? And then finally, because the judiciary is also there, there are three most popular organs of the government: executive, parliament, and judiciary. So all these institutions, they are created under the scheme of the constitution. What is their function, what is their role, what is their responsibilities, what are their limitations? All these things are pointed out, are laid down under the scheme of the constitution. Uh, I suppose that all of you may be having bare information about all these institutions. Now, apart from this, The Constitution of India also incorporates some of the valuable and absolutely essential rights for the citizens of the country, that is, for the people of this country, and they are known as fundamental rights. So there is a separate chapter, chapter third, under the scheme of the Constitution, and under the chapter third of the Constitution, the rights which are guaranteed or which are enshrined for the people of this country, they are known as fundamental rights. Starting from Article 12 to Article 35 of the Constitution, they guarantees some of the absolutely important rights which are called as fundamental rights. Why are they called as fundamental rights? I think those who are from the field of law, from law background, I think they will be fully aware as to why these rights, the rights which are guaranteed under Article 12 to Article 35 of the Constitution, are called as fundamental rights or basic rights of the citizen of the country. But in brief, it may be pointed out for those who are hailing from other discipline, maybe science faculty or maybe faculty of engineering or some other faculties, as to why these rights are called as fundamental rights. Uh, uh, in brief, the rights which are guaranteed under article of under part third of the Constitution, they are called as fundamental rights because they are fundamentally, absolutely essential for the dignified survival of the human being or a human being in a given circumstance. Without or in the absence of these rights, the survival of a human being may be possible. But these rights, starting from Article 20 or Article 12 to Article 35 of the Constitution, basically they ensure, they guarantees not only the survival, but they guarantees the dignified survival of every individual or of every citizen of this great nation, that is of India. Since they are absolutely essential, they are indispensable, they are necessary not for the mere survivor, but for the dignified survival, for the dignified survival of the human being in a given circumstance, in a given society, in a given situation. Therefore, these rights are called as fundamental rights. And therefore, the framer of the constitutions, they created a separate chapter having regard to the importance, significance of these rights, because they were well aware that without these rights, it may not be possible for the individual citizen of the country to uh, lead a dignified, respectful life in a given society. And therefore, a separate chapter, uh, that is chapter third, was created and was put under the scheme of the constitution. Not only they are absolutely essential for the dignified survival of the human being, but at the same time, the framer of the constitution also made a successful attempt to make them, to render them justifiable. Means, uh, at any point of the time, in the given circumstance, if any individual of this great nation, who is citizen of this great nation, is arbitrarily deprived or denied any of the rights guaranteed under the chapter third of the constitution, then the aggrieved person or the citizen will have the right to be redressed by the judicial authority. That is, he will be entitled to the judicial remedy for the constitutional remedy. He will be entitled to the constitutional remedy under the Article 32 of the Constitution. And not only aggrieved person, because sometimes one who is really aggrieved, he can claim the constitutional remedies by invoking Article 32 of the Constitution. Even if anyone who is not directly affected, but he is a public spirited person, he is having the genuine interest in the right which has been violated by the state itself, or by any authority of the state, or by any instrumentality as identified under Article 12 of the Constitution. Even a public spirited person having the interest therein can also go, he will also have the locus standi under Article 31 of the 32 of the Constitution, and he can also approach to the Constitutional Court, that is to the Supreme Court, or he can approach to the High Court. He can knock the door of the Supreme Court under Article 32, invoking the jurisdiction of Article 32 of the Constitution, and he can also prefer to go the respective High Court by invoking Article 226 of the Constitution, and in this way he can file a public PIL, that is public interest litigation, and can have the constitutional remedy from either High Court or from the Supreme Court, even if he is not directly affected by any action of the government which is arbitrary and has resulted into the infringement or violation of the fundamental rights as guaranteed under part 3rd of the Constitution, ranging from Article 12 to Article 35 of the Constitution. Ladies and gentlemen, now you can imagine being a teacher, having a intellectual background or educational background, how important these rights are, particularly in contemporary socio-political scenario. Because now there is a government, almost every government in power, in the name of law and order, takes so many actions which ultimately result into the deprivation of fundamental rights, basic fundamental rights. Had these rights not been in place under the Constitution, what could have been the state of the situation of the society in which we are putting up right now? Now, in the name of all of you may be well aware that what happened in the name of law and order. How many people are taken into the custody? Sometimes they are taken into custody without any valid reasons. So now, if this type of the situation arises or happens with any individual, the individual will have right to have the recourse of these provisions which are given under part 3rd of the Constitution. He can go to the High Court, he can go to the Supreme Court, and can seek the constitutional remedy even against the action of the government. There are so many cases of reported have been decided by the Supreme Court of India, and the most popular case, because since we are talking about the fundamental rights, and therefore now by means of the judicial interpretation how the scope of these rights have been enlarged time to time by the Supreme Court, it is evident from the successive judgments on various subject matters. Uh, uh, now, we can just, for example, make the reference of some of the areas that now the right to education, uh, in fact, is not directly traceable under Article 21 of the Constitution. And therefore, until the insertion of Article 21A in the scheme of the fundamental rights, right to education was not a fundamental right. It was not a fundamental right. But in the course of time, by means of interpretation of Article 21 of the Constitution, right to life and right to liberty has been given a wider interpretation by the Supreme Court. And while enlarging the scope of Article 21, or particularly right to life and right to liberty, now the Supreme Court has read that right to life also includes the right to education. Earlier it was not so. But now the Supreme Court has read in Article 21 that right to education is also implicit in Article 21 of the Constitution. Therefore, right to education should be regarded as a part of the fundamental right. And the government ultimately, pursuant to the consistent decision of the successive decision given by the Supreme Court, amended the Constitution, and Article 21A has been added to in the scheme of the Part 3rd of the Constitution, and now the right to education is also a fundamental right. As to why this article has been enlarged, as to why this right to education has been considered and read within the meaning of the right to life, because Article 21 of the Constitution simply guarantees the right to life, and right, nobody shall be deprived of his life and personal liberty except according to the procedure established by law. And therefore, if one goes by the Article 21 of the Constitution, one will find that the, Article 21 of the Constitution contains only two lines. That one shall not be, no one shall be, means no citizen of this country or no one can be deprived of his life and personal liberty except according to the procedure established by law. Means right to life, that one who is born as a human being, he is ensured by Article 21 of the Constitution that he has the right to live. He has right to live, he has right to survive in the given circumstance, in the given situation. And no one, including the state, has got the power to deprive anyone of this country of his life as well as of personal liberty, except according to the procedure as provided under law. Now, what is the life? What is the life? Now, earlier, in the beginning of the, when the Constitution was enforced, because as all of you know that uh, Constitution was enforced on 26 January 1950, along with the fundamental rights. So, in the beginning, all of you may be well aware about Khadak Singh case and some other cases wherein the concept of life was came for consideration before the Supreme Court interpreted, but a very narrow interpretation was given, to the right to life. But with the passage of the time, advancement of the society, uh, the concept of the right to life has been expanded. Horizon of the right to life has been expanded by means of interpretation of the expression life by the Supreme Court itself. And in Menaka Gandhi and other cases, the Supreme Court held that life doesn't mean a bare life, but life means a dignified survival, a survival with the dignity, with human dignity. Now, what is essential for the human survival with the dignity? It will depend upon the attending facts and circumstances. Now, therefore, now the Supreme Court has has come out with the interpretation that a human life without education is no life. It will be just like a bare existence. And therefore, now the government has been put under the duties, under the constitutional duties. Because at one hand, the Constitution guarantees the fundamental rights under Chapter 3 of the Constitution. On the other hand, under Chapter 4A, the Constitution guarantees certain duties, though these duties are for the citizen of the country. But there are certain constitutional moralities, constitutional guarantee. So now the government is under duty to ensure dignified survival of the citizen of its country. And for dignified survival of the citizens of this country, it is essential that they should be properly educated. There should be there should be proper arrangement for the education of the people of this country. And therefore, the Supreme Court considered that right to education is implicit in Article 21 of the Constitution, and therefore it should be considered, rather accepted by the government as integral part of Article 121 of the Constitution, as integral part of the fundamental rights. And government was also mandated that in order to translate into action right to education, the government should also take some necessary steps for proper implementation of right to education. And therefore now uh, right to education act has been enacted by the parliament, and now the education up to certain age has been made compulsory and free. And therefore now under part 4a, uh, under part 4, uh, article 51a of the constitution, a recent amendment was made in 1986, and in article 51a, provision k was added to by 86 amendment, and that provides that anyone who is parent or guardian to provide opportunities for education to his child, or as the case may be, ward between the age of 6 and 14 years. So at one hand, the government has been mandated to take the necessary step for the proper education of the people of this country. At the other hand, on the other hand, Article 51A subclass K also put the parents of every child under a constitutional duty to make the necessary arrangement for the education of his child, children are ward as the case may be. This is the constitutional duty of every individual parent of this great nation under Article 51A(k) of the Constitution, that he should make the necessary arrangement out of his or her own resources for the education of his or her child, children, or what as the case may be. So there is a nexus between Article 21A and Article 51 A subclass K of the Constitution, because right to education is basically essential, is absolutely essential. It is indispensable not only for the survival but for the dignified survival in the given society. And therefore, now the government is mandated to take the necessary step for opening the school, colleges, university, and rather the government is required to spend a good amount of the GDP on the education system. Uh, Respected audience and participants, whereas Article 21 of the Constitution guarantees right to education as a integral part of the fundamental right. Wide Right to Education Act, government has taken the various necessary steps for the education, for creating the educational infrastructure for the people of this country. But this is not basically enough. If we look into the spirit of the Article 21 of the Constitution, 21A of the Constitution, that guarantees the right to education. Not right to education as bare survival is not guaranteed under Article 21 of the Constitution. Rather, survival with the dignity is basically the spirit of Article 21 of the Constitution. In the same way, not only the education is guaranteed wide Article 21A of the Constitution, rather, a quality education is guaranteed under Article 21 of the Constitution. And therefore, if the government in power or system in the place is failing to make the necessary arrangement for the quality education, means system is failing to implement the mandate of Article 21A of the Constitution vis-a-vis Right to Education Act as passed by the central government. This act was elected in 2000. देखिए क्या नेटवर्क तो नहीं चला गया. Hello, hello, audience. Am I audible?
Yes,
Yes,
sir.
sir. Yes, sir. You are
Yes, sir.
audible, sir.
Audible, sir.
Yes, sir. Yes, sir. Am I audible? Well, sir, thank you very
Yes.
much. So now here, since we all are a responsible person, we are part of the education system. We are also a responsible citizen of the country, society, because we are not only responsible for ourselves, but basically our responsibility is vicarious, joint and several, because we have certain duties towards our society, our people, our family, our relation, our known person. So now the point is that whether this simply amendment in the Constitution, adding Article 21A guaranteeing right to education as a fundamental right under the scheme of the Constitution, and passing the law, that is Right to Education Act 2005, is sufficient so far as the spirit of Article 20, because all the rights which are guaranteed under the chapter 3rd of the Constitution, they are not only right, but rather they are sacrosanct right. and no one can take away these rights. No one can deprive of these rights. And if anyone is trying to take away, abridge, or belittle these rights, in fact, he is violating Article 21 of the Constitution, for which constitutional remedy is guaranteed under Article 32 of the Constitution. And therefore, now the point for consideration for all of us is whether the mandate of Article 21A of the Constitution is basically translated into action in reality at the grassroots level. Now, if you conduct the survey of your surrounding, of your localities, particularly of the government school and colleges. Now, pursuant to the Article 21 and successive judgments handed down by the Supreme Court, Article 21 has been created. Our right to education is guaranteed as fundamental right. And in order to translate into action the mandate of Article 21, a special law has been enacted. And by enacting the special laws, the right to education is guaranteed by the government in power, maybe state government or maybe central government. Higher education is under the jurisdiction of the central government, and the primary education basically is under the jurisdiction of the state government. But what is the state of the situation of our school and colleges at the grassroots level? If you collect the data, you will arrive at the conclusion that what pathetic condition is of those school and colleges basically which are responsible to fulfill requirement of Article 21A of the Constitution. In books, in law, so many things are guaranteed that at every 30 students there will be one teacher. If the number goes beyond the 30 or 40, the number of the teacher will be 2 and 5 and 6 and so many things. And uh, 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 there should be school, and in the school all these infrastructures should be there. So many things are guaranteed as per laws, as per the rules given under the Right to Education Act, etc., etc. But what is at the grassroots level? That there are so many schools, primary, junior, high school, and even colleges, inter colleges, wherein there is no teacher. The school is being run only by one Shiksha Mitra. One Shiksha Mitra, and number of the students in the school may be 100 and several hundred. Second thing is that under the Constitution, Article 51A, parents are under duty to make the arrangement for the education of his or her wards or children. Now here in this area, here also, because how many people are basically concerned about the career of their children so far as the education is concerned? Does we fulfill the requirement of Article 51 AK of the Constitution that mandates that all the parents should take the necessary step, make the necessary arrangement for the education of their children? And here again, even the parents are also under the duty not only to make the arrangement for the schooling or education of their children, Rather, they should also make the necessary arrangement for the quality education of their child. If there is no arrangement for the quality education of their children, means we are violating fundamental duties as given under Article 51 A of this Constitution. So basically, here these are the points which are to be taken, because so far the fundamental duties are concerned, one can go through chapter 4 A and can read out Article 51A of the Constitution. Earlier, the number of the duties as provided in Article 51 were 10. Now one has been added. Now their number is, total number is 11. It is given, one can read, but basically it is not the subject of the reading. Rather, it is subject of pondering over it, that what is the state of situation of our fundamental duties so far as the grassroots level implementation is concerned. Now, if you go through, this is the thing, because uh, these provisions under the scheme of the Constitution, they are basically very valuable provisions. They are very important. They are very significant so far as the life of the individual is concerned, and how much we are aware about all these things, because lack of the information is also a source of the problem, because many people of the this country, they are not aware for the lack of proper education, for the lack of proper information so far as their rights and duties are concerned. So this is still a uh, continuous problem of our country, particularly of our society, because many people are not knowing that what are their rights which are guaranteed under this national document known as Constitution, and in case those rights are not being fulfilled, then what action can be taken by the aggrieved person or party, and what type of the remedies can be claimed by invoking these provisions of the Constitution. So basically, this is the problem, and therefore there is a requirement that a wider publicity mechanism should be adopted in order to make the people aware about these fundamental rights and fundamental duties which are guaranteed under Part 3rd and Part 4 of the Constitution.
Assalamu alaikum, Professor Wasim
Wali-
Saab. This is Dr. Faiza here, and
yes.
I just wanted to welcome you and thank you for this wonderful session. I've been listening to you for quite some time, and I believe participants are also listening in rapt attention. So, yes, there are thumbs up coming up. So, uh, friends, I would like to tell you that Professor Wasim is a very busy person. And Zishan Bhai, Assalamu alaikum.
वालेकुम सलाम मैम,
हम्म,
खैरियत से हैं मैम?
जी जी जी, शुक्रिया बहुत बहुत। तो मैं माजरत के साथ, इतने अच्छे फ्लो में लेक्चर चल रहा है वसीम साहब का, लेकिन हम अपने को रोक नहीं सके। हमने कहा कि इनको हम दोनों मिलके खैर मकदम करें पहले यहाँ पे अपने कोर्स में।
जी मैम,
जी
यस
जी, and you would realize he's extremely busy, but then he found time for us. और वसीम साहब, ये हमने जो कोलैबोरेट किया है इंटीग्रल यूनिवर्सिटी के साथ, तो माशाल्लाह आप देख लीजिए जी, 108 लोग हैं और भी होते हैं, और ये हमारा बहुत पुराना इंटीग्रल के साथ एक रिलेशनशिप है। करीब करीब 10 कोर्सेज हम इनके साथ कोलैबोरेशन में कर चुके हैं, और ये अकील साहब की और जीशान साहब की जो टीम है, it's really working wonders and bringing these courses to the participants.
थैंक यू मैम, आपने हमें जोड़ा अपने इस प्रोग्राम से, और इनफैक्ट हालांकि मैं कहना नहीं चाहता था, लेकिन इनफैक्ट वाकई में अभी देखिए आप जब बात कर रही थी तो मैं इशारों से बात कर रहा था, चूंकि थोड़ी सी प्रॉब्लम आ गई है। वो
जी जी
कश्मीर के लड़के कुछ है मसला, और उधर से
जी।
डिस्ट्रिक्ट एडमिनिस्ट्रेशन का बार बार फोन आ रहा है
बार
कि
बार,
आप
हाँ।
कहाँ हैं, आप कहाँ हैं, और मैं
आई कैन
उठा नहीं रहा हूँ
अंडरस्टैंड।
हालांकि लेकिन फिर भी मैंने
The job of
पार्टिसिपेंट
this
से
doctor is very, very, very sensitive job, sir.
Yes, yes,
Very
and he's
sensitive.
been performing it for
बट हमारे लिए ये बहुत ही मतलब आई फील प्रिविलेज कि मुझे ये मौका मिलता है आप लोगों से बात करने का। और लेकिन मैं उससे ज्यादा अहमियत इसको देता हूँ जो जिस प्रोग्राम में हम जुड़े हुए हैं, आप हम सभी लोग जुड़े हुए हैं। वो तो खैर है ही है, बेसिकली हमारा काम तो यही है जो हम कर रहे हैं। लेकिन जाहिर सी बात है कि अभी वहां पर मैं 2 मरतबा निकला मीटिंग से बाहर, तो फिर वाइस चांसलर ने कहा आप बाहर बार बार जाने क्या खैरियत है सब। मैंने कहा मैडम अगर बाहर खैरियत ना होती तो आप अंदर बैठ कैसे पाती, तो ये बात तो तो ये
बिल्कुल
बात थी
बिल्कुल
बहरहाल।
बिल्कुल। हाँ
चलिए
नहीं, दिस
तो
इज
अभी
ही
थोड़ी
इज अ
देर मैं और
वेरी वेरी
थोड़ी देर और मैं इनसे बात कर लूं,
एक्सट्रीमली।
क्योंकि हमारे ऊपर प्रेशर हो रहा है, वहाँ डिस्ट्रिक्ट एडमिनिस्ट्रेशन का बार बार फोन आ रहा
जी
है कि आप
नहीं, आप
कहाँ हैं
थोड़ी देर
कहाँ
पहले, बस 15-20 मिनट में आप चाहें तो खत्म कर लें,
हैं।
नो
जी
प्रॉब्लम।
जी जी बस हाँ, हालांकि मैंने भेज दिया टीम के लोगों को, लेकिन वो बराबर उनका फोन आ रहा है एसपीसीटी का, तो जरा से देखता
नहीं,
है।
आई
ठीक है
कंप्लीटली
ना।
अंडरस्टैंड। ऑल द
हाँ
बेस्ट,
जी
प्लीज गो
जी
अहेड, प्लीज गो
ठीक, थैंक यू थैंक यू। So, respected participant, I was talking that uh, uh, so far as the rights are concerned, law in book is concerned, all of you are aware that so many things are guaranteed. This is not possible to uh, refer all those things. Just for example, I made the reference of right to education uh, as guaranteed under Article 21 of the Constitution. Now, just I was going through Article 51A, and this clause E of the Constitution. If you go through this provision, in the last line, you will find that to promote harmony, spirit, common brotherhood among all the people of India, transcending religious, linguistic, regional, or sectional diversities. Now, in the last, a very important point is mentioned to renounce practices derogatory to the dignity of women. Because you see that 50% population of the country is of the female. We all are aware that almost uh, 50 50 are, uh, is the ratio of male and female in the country. And therefore, Article 51A of the Constitution has put every citizen of this country under the constitutional duties to respect the half population of the country, that is to the female. And therefore, in the Constitution, Article 51, it is clearly given that one will renounce practices derogatory to the dignity and status of women. This is the duty of every citizen of the country, that everyone will renounce, will give up, will not practice anything which is derogatory to the dignity and maybe ritual, maybe practice, whatever may be, meaning thereby that any ritual may be of social importance. So any ritual which is derogatory to the dignity and status of the women shall not be practiced henceforth, will be renounced. and not only renounce, but everybody will make the effort that such type of the practices are not taking place in and around of him or her, whatever may be the status. So it is the duty of the citizen to see that neither he nor in his surrounding anybody is doing anything which is anything which is derogatory to the dignity or status of a woman. What are the uh, practices derogatory to the dignity and status of the women? This is the point of the concern. It is not given. What are the practices which will be derogatory to the dignity and status of the women? It is not pointed out under Article 51 E of the Constitution. But now they have been identified. They have been identified as to what may constitute practices derogatory to the dignity and status of the women. And therefore, law has been also, because now there is a point that so far as the fundamental duties are concerned, fundamental rights are justifiable, that if there is a violation of the fundamental rights, any of the fundamental right, then the aggrieved party will have the right to move the High Court or the Supreme Court under Article 32 or under Article 226 of the Constitution. Can seek the constitutional remedies, can seek the compensation, can seek the punishment from the government against the government. But so far as the fundamental duties are concerned, fundamental duties are not justified. No punishment is directly provided for non-fulfillment of the fundamental duties. For example, sexual harassment. Now, any kind of the harassment, may be physical, may be mental, sexual, whatever may be, means any kind of the harassment, any kind of the disrespect to the women in any form is viewed or has been viewed by the courts as harassment of the women. And any kind of the disrespect or harassment, any form of the harassment of the female or women of any status or of any category, basically is violation of fundamental duties as given under Article 51A subclass E of the, because Article 51A subclass E mandates, requires every citizen of this country that he should not do anything disrespecting his counterpart of female, means counterpart population, that is the women. And therefore, disrespect or harassment in any form at any place is totally prohibited. And if anyone is found indulging in the sexual harassment of the women or mental harassment of the women or showing the disrespect in any way to the women at any place, is liable to be punished. Therefore, sexual harassment at workplace has been made a law. A law has been enacted by the parliament, and this law has been basically enacted pursuant to the decision of the Supreme Court in Visakha versus state of Rajasthan. Now, sexual harassment basically is prohibited indirectly under Article 51A E of the Constitution. But sexual harassment or harassment of a women is not only violation of fundamental duties, but it is also violation of Article 21 of the Constitution, because right to life with dignity is also guaranteed under Article 21 of the Constitution. And therefore, as and when there is a violation, there is a sexual harassment of any women in any form, then there is not only violation of Article 51K, which is non-justifiable, but indirect, it also affects the Article 21 of the Constitution that guarantees the right to life with the human dignity. And therefore, what is not justifiable directly, that is just that has been made justifiable indirectly under Article 21 of the Constitution, because right to life doesn't mean the bare life, animal life, bare existence, rather with the dignity. And the harassment in any form basically is a kind of affront on the dignity of an individual, on the respect of an individual, particularly of the women. And therefore, encroachment, while that is the sexual harassment, may be direct or may be indirect. In fact, is a kind of the encroachment upon the life, not only upon the life, but even upon the dignity which is implicit in the right to life as guaranteed under Article 20. And therefore, in Visakha versus state of Rajasthan, after a long period of the enforcement of the Constitution, because Constitution came into force in 1950, and Visakha case has been decided near about after 35 years. And in Visakha versus state of Rajasthan, Supreme Court, expanding the horizon of Article 21 of the Constitution, held that the sexual harassment in any form is basically affront on the dignity of an individual women, and therefore it is violative of Article 21 of the Constitution. It is violative of Article 51E of the Constitution. And therefore it was directed that in order to ensure the proper dignity of the individual women, it is necessary that law should be proper, law should be enacted. And therefore, the Supreme Court in Visakha laid down certain guidelines. What is the sexual harassment? How the sexual harassment can be prevented? What will be the duties? Because if it is harassment at the workplace, then it will be the duty of the employer. So how the employer, what will be the duties of the employer, under whose supervision somebody is working as a woman? So all these guidelines were laid down by the Supreme Court, and subsequently the guidelines laid down by the Supreme Court in order to prevent the sexual harassment that has been converted into the form of the law. Now there is a Sexual Harassment at the Workplace Act in a proper form. So now these laws have been basically enacted in order to prevent the sexual harassment offenses against the women. Now these laws have been enacted basically pursuant to the mandate of the Article 21 of the Constitution, read with Article 51E of the Constitution. And in this way, what is non-justifiable has been made justifiable by in other way, that is by enacting the laws. But now the Constitution, Article 21 of the guarantees the life with dignity. And no one is allowed to encroach upon the dignity of the individual, neither the state nor the individual. If the state has encroached upon the dignity of the individual, then the victim will be entitled to invoke the jurisdiction of the Constitutional Court, that is Supreme Court under Article 32. If somebody has been arrested without any reason, has been detained without any valid law in place, without a, so that is the violation of Article 21 of the nobody shall be deprived of his life and personal liberty except according to the procedure established by law. If somebody has been taken into custody without due procedure, and due procedure is also laid down by the law, then that arrest and detention will be illegal confinement, violation of Article 21 of the and if it has been done by the state or its authorities, then the aggrieved person can go to the High Court or the Supreme Court under Article 32 or under Article 226 and can get a order from the court, not only for the release, but also can also claim the appropriate amount of the compensation from the government. If somebody has been taken into the custody and he died in the custody of in the police custody or the law enforce custody of the law enforcement agency. Now, this is the grossest violation of Article 21 of the Constitution in view of the decision of the Supreme Court in Neelavati Behera versus State of Gujarat. Justice A.S. Anand, the then Chief Justice of India, he took a very serious note when he went through the fact of the case in Neelavati Behera case. Short story is that there was a poor lady whose son was taken into custody by the police on the charge of theft. He was arrested under section 379 for committing theft of some petty items. He was taken into custody by the police, local police, and for release, there was a demand for ransom, bribe. The poor mother, Neelavati Behera, could not make arrangement for the money and could not get secure the release of her son. And he was subjected to the torture in the custody and the boy died. Ultimately, writ petition was filed for custodial death and matter went before the Supreme Court to ultimately. And it was decided by the then Chief Justice, Justice A.S. Anand. And he granted a huge sum of compensation invoking the jurisdiction of Article 21 of the Constitution. And the poor lady was compensated in this way for losing his son. So, ladies and gentlemen, I was saying that any kind of the disrespect or harassment of the women is prohibited. Not only prohibited, but this is there is a constitutional duty cast upon every individual that one should show due respect to women in and around him or her, as the case may be. But state of the situation is very well, because so far as the harassment is concerned, sexual harassment at the workplaces is concerned, that is on rise, though various steps have been taken in order to prevent them. But situation has not improved as much as it is expected in view of the law in places, particularly constitutional mandate. So still the situation is not to the expectation of the provisions of the Constitution, maybe Article 21 or maybe Article 51 E of the Constitution. Another kind of the disrespect is demand of dowry. All of you may be aware that dowry is a curse. It is an offense. Demand for dowry is an offense under the Indian Penal Code. It is a serious offense, and if anyone is found demanding, then he can be subjected to. But in flagrant violation of Article 51E of the Constitution, this evil is very much in practice even today in our society. And still, cases of the bride burning, dowry death are reported. Cases are lost sometime, which is very painful. That after about 70, 75 years of the enforcement of the Constitution, is still Article 21 maybe, or maybe Article 51 mandate of Article 51 are not fully respected by the people of this country. And therefore, once upon our President of India, former President of India, K. Narayan, said that because a review of the Constitution, a committee was constituted to review the Constitution, what amendments can be made, is there any fault in the Constitution, and therefore a commission was constituted to review the Constitution. Various, and then at one occasion, the president, former president, said that basically in Constitution there is no fault. Constitution has not failed, but we have failed the Constitution by our act and conduct, and that is true. Uh, if we examine and take the provisions of Constitution at the grassroots level in practical life, Constitution Article 51 clearly prohibits disrespect to the women. Article 21 of the Constitution guarantees right to life with the dignity. But what is happening at the grassroots level, we all are aware. That is the point of concern for all of us. Do we really respect this sublime document which is known as the Constitution? Do we really respect the various provisions which are provided under Part 3rd of the Constitution, Part 4? This is the, so there is a need for making the empirical uh, study of all these provisions, and we have to think over as to how or how can we contribute to take the spirit of the Constitution, or how can we translate into action the spirit of the Constitution? What will be our, what is our responsibility, what is our duty? Because Constitution guarantees not only rights but also duties. So at least our duty is to make the people aware about the rights which are guaranteed under Part 3rd and the duties which are provided under Part 4A of the Constitution. And we should take a pledge in view of these provisions of the Constitution that henceforth at least our behavior will not be disrespectful to our female partners, friends, known, colleagues, students, whosoever, whatever may be uh, connection by one with the uh, female females, because this is the spirit of the Constitution. Unity, integrity. And now I see that there are so many things which are in violation, taking place in violation of article, these provisions of the constitution, maybe part third or maybe part fourth of the constitution. Now that it is the duty of individual citizen of the country to develop a humanistic temperament, scientific temperament, brotherhood. But what is happening at the grassroots level, we all are aware. How far we have gone from the spirit of the constitution. I have given the example that right to education is a fundamental right. But access to the right to education has become very difficult for a normal person of the society. Now, medical, you see the case of the medical education, engineering, if somebody wants to educate his child in a private institution, in medical college or engineering college, so he will have to pay lakhs and lakhs of the rupees. Article 21 of the Constitution guarantees right to education. Right to education means right to proper education, quality education, relevant education. Relevant education. What is relevant for a particular person? It depends upon his and her attending facts and circumstances. But is there proper arrangement for a poor student to have access in the higher education free of cost or at the cheaper rate? Now, fees of the school and colleges is rising day by day. At one hand, we are boasting that we have the right to, we have school and colleges, government school and colleges. But the position of the school and colleges, we know. Then at one other hand, there is private school and colleges. Their condition may be good. System of education may be quality system of education. But fee is so high that it goes beyond the capacity and competence of the individual person, and therefore this is also indirect deprivation from the right to education as guaranteed under Article 21. Things have been made so costly, so difficult, that it is beyond the capacity of beyond the resources of the individual in the given circumstances. So this is another way of depriving the right to education. On one hand, it is guaranteed up to class 12, there is a provision for the free education. But in the school and college, there is no infrastructure. There is no human resource. So this is the otherwise, in other way, denying the right which is guaranteed under Article 21. So basically, these are the some problems which are at the grassroots level. How to overcome them? Basically, this is the point which is to be discussed, to be taken into consideration, and there are so many other things uh, that I wanted to discuss, but now since we are running shortage of the time, and I am also already exhausted. In fact, therefore now I wind up here with thanks to all of you joining this session. That is so. My humble submission is that since we all are teachers, therefore whatever subject we teach, we study, it should be basically studies from the practical point of view, particularly those who are hailing from the faculty of law, department of law, teaching in any law subject, because what is law in book and what is law in practice, and how they differ from each other, and then what is the remedy available, and how the law in book and law in practice can be reconciled, because uh, if law in book is not properly implemented at the grassroots level or in practice, that is useless. That is useless. And this is the problem. The right to health. Right to health is also read under Article 21 of the Constitution. But what is the condition of this, our health system at present, so far as the government hospital are concerned? So these are the basically. So our approach should be empirical approach. Our should be our practical approach. Only then we can contribute so far as the improvement in the infrastructure or the system is concerned. So thank you very much, Dr. Danish. Now my points are over. And if anybody, any participant want to ask any question or relating to the subject itself or relating to any point, you are welcomed.
Dear participants, if you have any question, ask the professor quickly.
Hello, sir. Very good evening. This is Ashima Negi. Sir, I have a question and a situation to share with
Oh,
you,
okay,
and I
okay.
would like your
Welcome,
enlightenment.
welcome.
Sir, recently, today morning, I had a lecture and I was teaching final accounts in the class. Now, when we were discussing various entries such as assets and liabilities, one of the boy student actually asked me this question because it was a discussion round. He asked me, ma'am, how will we uh, write the gifts which we receive in marriage if we have to prepare a balance sheet? In which section will it be liability? Will it be asset? Now, obviously, this question was very much out of context. But if you could just enlighten how to write it, because when this question was asked to me, what I did was that why you need to actually go in and term the dowry system as gifts and actually go ahead and go on with this tradition.
So
So
what was the specific question?
the question
Specific
was, how if a person receives gifts in case of
gift.
marriage.
Huh.
Yeah, because this is a new term for dowry that
Hmm,
people
hmm,
ask for gifts or they give gifts. So the
hmm,
new term in the market, rather than calling it dowry, it is actually gifts what they
hmm,
refer to.
hmm,
So the
hmm,
boy out of blue just comes and asks me this question. He was sitting in the second row, so he was very
hmm.
attentive. And he asked me this question, ma'am, how would in the balance sheet, where would we write the gifts? Will it be asset side? Will it be liability something? Because we were discussing like a swimming pool is actually is it a asset or a liability? We were discussing all those things which could be tangible, intangible assets. So the discussion was totally around the balance sheet content. But then he talked about
Yes.
sir,
I got your point.
sir,
Now, if you go by the definition of the gift,
sir.
because gift is a legal term and it is well defined under section 122 of the Transfer of Property Act, right? There
Okay.
is a full chapter under the Transfer of Property Act, that is gift.
Okay.
Basically, now I'm not going by the definition because it will take a lot of the time. But
Sir.
I am saying that if there is some presentation or something has been presented on the occasion of the marriage,
Okay.
and that falls within the definition of the gift as provided under Article 120 or Section 122 of the Constitution, Section 122 of the Constitution. So that will be the personal property of the receiver of the gift, because gift is something which is given by one person to another without any consideration, without any return, or without any use. So
a
once
decent.
something has been presented without any consideration, then that the person who receives the gift immediately he becomes the owner thereof, real owner thereof. And since he becomes the owner thereof, therefore it will become his property. It will become his property. He will be the bona fide owner thereof, as he may be the bona fide owner of some other properties in his or her possession. So
So,
it
one more question. So, is it actually a little ethical to talk about this area wherein dowry has been practically termed as gifts, and we should actually let it happen in classroom discussion? That is my question.
So
Because
you
I
see,
think at the basic level, it should be something which should be.
here, yes, sir. Ravi, right. I try to understand.
Sir.
Gift and dowry, these are the two different legal expressions.
Okay, sir.
And both have a legal definition.
Okay, sir.
Dowry is also defined under section 113B of the Indian Penal Code. Now, section has changed because BNS Bharatiya Nyaya Sahita has come into place. There may be some other section, but there is a definition of the dowry. If
Okay.
something falls within that very definition, then that will be a dowry, and dowry can never form the part of the personal property.
Okay, sir.
Yes, because that has a different meaning, that has a different scope. But so far as the gift is concerned, gift is entirely different. So now it depends upon the attending facts and circumstances. Does the presentation fall within the definition of 122 or section 113B of the Indian Penal Code? So it is subject to the analysis in view of both the definitions. If it is within 122, our core personal property will be personal asset. If it is within section 113, perhaps it was 304, sorry, 304B, then it will be a dowry, and dowry cannot be treated as personal property. And since it will not be a personal property, then it will not be in the category of asset and cannot be entered in the entry of asset.
Okay, sir. Got it, sir. Right. Thank you, sir.
सर हमारा एक क्वेश्चन है।
हाँ हाँ
सलाम सर।
वालेकुम सलाम।
इरफान अहमद खान।
जी इरफान सर।
सर मेरा क्वेश्चन एक ये था कि जो आर्टिकल 51K का तो जो ये बना है उसमें ये सोवियत संघ जो इंस्पायरेशन से बना है, तो उनकी उसमें क्या खास बात थी, मतलब उसको थोड़ा सा शॉर्ट। जो 51K आर्टिकल जो अभी इसमें आपने बता रहे थे डिस्कशन में कि 51K आर्टिकल्स का, तो वो इंस्पायर हुआ या 42 करेक्शन हुआ था उसमें?
No, you see that so far as the 10 duties are concerned, they were incorporated under chapter 4A in wide 42nd amendment. But this article, this last duty, which is under the article 51K, is a new development, and therefore having regard to the article 21A, because article 21A because Supreme Court was reading consistently, continuously, right to education within the meaning of article 21A of the Constitution, right? Since it was regarded as a fund.
सर मैं भी बोल सकता, सॉरी सर, हम ये कह रहे थे एक बार जो है इंटरनेशनल जजेस की जो है एक मीटिंग हुई थी, तो उसमें कुछ डिसीजन लिया गया था कि उसमें कि जैसे शांति में या उसमें इस तरह से। ठीक है सर, हम समझ गए, बस ये है कि वो इंस्पायरेशन के लिए बना था सोवियत संघ से, तो उसमें क्या खास बात थी, बस यही पॉइंट था।
चलिए ठीक, समझ गए तो बहुत अच्छा। थोड़ा सा और लोगों को बता दीजिए ना हो।
थैंक्स।
Yeah.
जी सर।
If you have any specific question, please ask, sir. Or I think, sir, there is no question left. So, sir, thank you very much for sparing time from your busy schedule. I understand that You are such a busy person, and you have spared so much time and given great insight on the constitutional duties and responsibility and the rights. So that will be very helpful for us in our academic and personal life. So thank you very much, sir, for your
So I am also
kind
thankful I am
Jazakallah,
also
sir.
thankful to all of you to be with us for more than 1 hour. Once again, I am also thankful to all of you.
Thank you, sir.
Okay.
Jazakallah.
Okay.
Thank you, sir. Thank you, sir.
Thank you, sir. Thank you.
Okay, participants, we will meet again.